Thank you everyone for joining us in the Law Theatre. Our panel will be providing first-hand information and answering the pre-submitted questions about the upcoming referendum. We would first like to acknowledge the Bedigal people that are the traditional custodians of this land and pay our respects to the elders both past and present, and extend that respect to other Aboriginal and Torres Strait Islanders who are present here today. Before we get started, my name is Matthew and this is Shan Zay, and we are fortunate enough this year to be the co-presidents of the UNSW Law Society and to be hosting this panel for the historic voice referendum. Before we get started on all your questions, we'd like to introduce our lovely speakers here today. Bridget Cama is a Wiradjuri and Pacifica Fijian woman who was born and raised in Lithgow and has connections to the Cudgegong River just outside of Mudgee. Bridget has been working with the Uluru Dialogue since March 2019, is an associate of the Indigenous Law Centre at UNSW and legal support team to the Uluru Dialogue. Bridget is also the co-chair of the Uluru Youth Dialogue alongside Lyra Davis, who work closely to provide a national platform for First Nations youth voices to be heard in the Uluru movement and the First Nations affairs.
We're also joined by Associate Professor Sean Brennan. Associate Professor Sean Brennan is Director of the Indigenous Legal Issues Project at the Gilbert and Tobin Centre of Public Law at UNSW Law Justice, and he was the Director of the Centre from 2014 to 2018 as well. His teaching, research and engagement focuses mainly on constitutional law, native title and Aboriginal land rights. As a non-Indigenous lawyer, Sean has worked with a variety of Aboriginal organisations before and since joining UNSW, going back to 1994. In 2016 to 2017, he was part of the pro bono legal team that supported regional dialogues of the First Nations Constitutional Convention, the deliberative process which culminated the Uluru Statement from the Heart. Thank you, Bridget and Sean, for joining us today.
This event is being held as part of the UNSW Law and Justice Plus Justice Festival. The Plus Justice Festival is an initiative to bring together staff and students and get us all thinking broadly about how cultural texts connect with this year's theme of home and the broader society. To find out more about the Plus Justice Festival, please head to the UNSW Law and Justice website. To get started, I'd like to invite Bridget to provide an overview of the Uluru Statement from the Heart and how we got to this point, and explain the question we will be asked to vote on the referendum.
Thank you. Before I begin today, I'd also like to acknowledge country, that we're on the lands of the Bridget people, and pay my respects to their elders, past and present, and I'm super grateful to have lived on Bridget land for nearly 10 years now, and started my family and raised my family on Bridget land, so very grateful for that. I'm just going to first talk you through the process and the journey that has led to this moment, this really significant national moment where Australians will have the opportunity to vote on the referendum and whether there should be an Aboriginal and Torres Strait Islander voice enshrined in our constitution. But this moment has had decades worth of work behind it and decades worth of advocacy by First Nations people. So specifically on the work that's been done on constitutional recognition of First Nations people, there's over 13 years of work that has been done and many processes during that time. But it wasn't until 2015 when a group of Indigenous leaders from across the country came together and met with the Prime Minister of the day, Malcolm Turnbull, and issued the Kirribilli Statement, which rejected symbolic recognition of First Nations people and also called for a consultation process, a meaningful consultation process with First Nations people to ask them what they thought, what we think about constitutional recognition of us. So that resulted in the Referendum Council being set up in 2015, and over 2016 and 2017, they worked with local and regional Aboriginal and Torres Strait Islander authority bodies to host what we know as regional dialogues. But the regional dialogues is essentially the consultation process that happened with First Nations people right across the country over 2016 and 2017, where over 1,200 First Nations people were consulted on what meaningful constitutional recognition means to us. So this is a map showing where the 13 regional dialogues were held. As you can see, they were right across the country. And just want to pay tribute to Sean, who was a key legal mind as well in the deliberative process of the regional dialogues, and worked alongside people like Professor Megan Davis, Arnie Pat Anderson, Noel Pearson, many others, both Indigenous and non-Indigenous leaders, constitutional experts made up the Referendum Council, but it was the Indigenous members of that council that actually deliberated on and created the consultation model, which I'll talk about a little bit now. The consultation process itself is very unique. It's the largest consultation that's ever happened in our country with First Nations people, and it's the only time that we've been consulted on the Constitution. So we were actually left out of those conventions that led to the Constitution being enacted in 1901. So it is a significant moment. So I just really want to emphasise that this was a process consistent with cultural authority and self-determination. Whilst the Referendum Council ran the consultation process, it was actually the regions and the local communities that put forward the delegates that were consulted as part of the process, and they had to be made up of at least 60% of traditional owners, people in our communities and cultures that hold authority. We are a gerontocracy, which means that our authority is with our elders, and at least 60% of those consulted had to be made up of those people. 20% from local Aboriginal and Torres Strait Islander community-controlled organisations, people who are on the front line, who are seeing the issues every day in their work and are also working towards evidence-based and local solutions that work for our communities. 20% was for the other people in community that didn't necessarily fall into the other two groups. Everyday people like mums and dads, young people were a part of that cohort, people living off country and members of the stolen generation. So this process was something that captured a diverse range of voices, people from a diverse range of lived experiences, and no one was excluded from this process either. From each of the regional dialogues, they sent delegates to the Constitutional Convention at Uluru, which is where the Uluru Statement from the Heart was issued to the Australian people. But there's so many other delegates that sit behind those at the Constitutional Convention that actually signed the Uluru Statement. That is where consensus was formed on the Uluru Statement. So over 250 delegates attended at Uluru. Out of those over 250, approximately 7 of those delegates walked out and did not agree to the process and the mandate that was put forward in the Uluru Statement, but the overwhelming consensus was on the statement itself, and those delegate signatures are found on the statement. So this is a picture when the consensus was reached on voice and Makarrata, treaty and truth. So these are the two key things that the Uluru Statement calls for. It is a sequenced pathway towards what those delegates at the regional dialogue said will achieve a better future for future generations, so that we aren't continuing to, see those statistics come out every year and the disproportional things that affect our communities particularly, as well as starting to address the disadvantage that exists in our communities. We are on the first step of this journey now as we head to referendum, but the Uluru Statement actually envisions first voice followed by treaty and truth. This is the proposed question that you'll be asked at referendum to vote on, and it is quite simple. It's very consistent with, in terms of its word count, with many other referendums before. It is not anything new in terms of the level of detail that's in it. And basically you'll be asked whether or not you agree to the Constitution being amended to establish a voice. That will be accompanied by the proposed amendment, which we'll talk a little bit more in detail in a minute. It will be its own new chapter of the Constitution, Chapter 9, which is also really significant in terms of a symbolic representation of us as a country moving forward on this new chapter, which is also represented in our Constitution. And that will be made up of section 129 and contain 3 key parts. Subsection 1 will be establishing the voice, to be called the Aboriginal and Torres Strait Islander voice. Part 2 captures the voice's core function, which is to make representations to both the Parliament and the executive government on issues that affect us as First Nations people. And the third part enables the Parliament to have the power to put a lot of meat on the bones. So what we're voting on in this referendum is a principle, which is very consistent with our Constitution. There isn't a load of detail in our Constitution. There's a lot of principles in that, and Parliament have the power to really put all of the meat on the bones which are laid out in the Constitution. One key question that we see constantly coming up in the debate, and which I'm asked about all the time on the ground, is, well, where's the detail? What is the detail? There is a lot of detail there. This is one part of it, as well as the proposed question and amendment, as well as all of the work that's been done over a decade or so. These design principles answer really plainly the kind of detail that I experience through my convers that are asked by people that I'm talking to on the ground. It's not the same kind of detail that Peter Dunn, for example, is asking for. And that's mostly around, well, what does this body actually look like? Who gets to select it? What will its functions be? So I just want to touch on 2 of these key design principles that were released by the Referendum Working Group, which was made up of Indigenous leaders and experts. And these will inform the piece of legislation that sets up the voice if there is a successful referendum. And the government has also committed to a consultation process if there's a successful referendum with First Nations people to also inform that piece of legislation. So I'll just touch on 2 of these, and I would encourage you to go look at these further following this session, and you can find them on our website as well as the government website. There's a bit more that goes to these, and I've just pulled out the very high-level stuff. So the first one is that the voice will be independent. That means it will sit outside of Parliament. It's not within Parliament, it's not within the government, it sits independently as an independent body, and will have the ability to make representations to Parliament and to the executive government. That also means that it doesn't have to wait until it's engaged by the Parliament or the executive government. It can actually be proactive. It can make those representations immediately following consultation with First Nations people who say, these are our priority areas that we want to make representations on, and here's what we want to put forward. It is the responsibility of the voice to do that, to meet with us as First Nations people who elect our representatives to the voice and really get into what are the priorities of the community and what are the solutions that you want to put forward on the issues that affect us. So we don't have to wait until something happens in our communities. We don't have to wait until the government or the Parliament are looking at putting forward a piece of legislation or a policy that affects a particular issue. We can actually be proactive in addressing that before we see the consequences of policies or laws that don't positively affect our communities. The other one is that this will not be another hand-selected or government-appointed body, which we've seen over our history. We've seen many bodies come and go in our communities within my lifetime. Even as a young person, I've seen 2 bodies come and go, which were set up in legislation and had the potential to really give us a voice and start to make those positive impacts but as soon as they were set up through legislation, they were pretty much taken away. There was no longevity there, no stability, and the constitutional element of this also means that it is protected there so that there isn't the ability for the government of the day, based on their politics or not liking the advice of the voice, to abolish it. It means that the voice will always be there. Doesn't matter what government comes and goes or the government's politics, that voice will always be there for us unless we go to referendum again and take it away. The other one is that the voice will be representative of our communities. So that means that to truly be a representative voice, it's really important that the voice reflects our diversity as First Nations people in terms of geographical location, gender, age, and other diversity. So that's another important point, and we can discuss further in our discussion any of the other points, but I would encourage you to go read about them further. In our communities, not everybody agrees, and that was also shown in the regional dialogue and convention process, which I've already discussed. I don't think it's a realistic expectation for all First Nations people to agree to one particular thing, whether it's the voice or not. First of all, we are very diverse in our nations in terms of cultures, geographical locations, law, and language. So we're diverse in that sense. We are also diverse in terms of our lived experiences, our politics, our ideologies. So we are just like any other group of people when it comes to those things. And there's a huge majority of First Nations people that do support the voice. And that comes from polling that was done in April, which says that 83% of First Nations people support this. I think we're going to get into some of the exciting questions that have been pre-submitted now.
Yep. So thank you so much, Bridget, for that very informative and detailed introduction. We will get stuck into some questions that have been pre-submitted by our audience. The first question that's been asked is, how may the referendum change the Australian constitutional landscape?
So I think from a personal point of view, the Constitution isn't always, seen as something that's very important in our lives as Australians. And through this work, I've realised that a lot of Australians even know that we've got a Constitution. They don't really know what a referendum is. So there's also a lot of that civics education going on in the work that I do. But I think the thing that I've reflected on most is what Professor Megan Davis says about a constitution having the ability to set out the material conditions for the way that we as Australians live our lives. Currently, our founding document, the Australian Constitution, doesn't formally or legally recognise us as First Nations peoples here on this continent for over 80,000 years. That's unfortunate, considering the Constitution is our birth certificate of this nation and really sets out the way our country is governed and some of those really key and core things that make Australia what it is, in particular our democracy. And I think this referendum, if successful, is not only recognising us in that Constitution, but recognising our place in this nation, on this continent that has been here for millennia, as well as recognising our diverse and rich cultures, which I think as a nation we need to celebrate. It should be something that everybody, no matter where you come from, how long you've been on these lands, what your connection to these lands is, we should all be able to embrace and celebrate that as Australians. So I think that'll be a key element of recognising us in the Constitution formally. And I hope that in terms of the constitutional landscape, that it does change the relationship between First Nations people and the government, and really allow us to participate meaningfully in our democracy. I think Australia has been a very successful democracy, but unfortunately First Nations people haven't been brought along on that journey. And I hope that this referendum will change that as well.
Yeah, I'd really echo that. I guess it's a great question. How does it change the constitutional landscape? And it could give rise to a broad range of answers, but I'll stick to loyally ones and just echo in part what Bridget's just said, I think, which is it deals with an overdue question of recognition for a really disturbing silence in Australia's highest law, our constitution, and also it's intended to change the dynamic in the way our parliament and our government does its business in Indigenous affairs and what opportunities there are for our First Nations peoples to participate in our political process. So I think those two things are really quite fundamental things for us all to contemplate in the run-up to a referendum. As Bridget said, it's an extraordinary thing, a source of pride for Australia that we have a continuous set of cultures and occupation of this continent for more than 65,000 years. If you think of the British or European presence on this continent, it goes back perhaps 9 or 10 generations at most, back to 1788. And prehistorians say 65,000 years is 2,000 generations or more. And yet we have a constitution that says absolutely nothing about that fact of these lands and waters that we now call Australia. And that, of course, has a history. From 1788, there was no recognition. In 1901, as Bridget has said, there was no involvement and recognition of First Nations people. There were laws that formally discriminated against Aboriginal people in terms of freedom of movement, freedom to marry, the right to vote, and so on. And it's only really relevant relatively recently in our history that those formal discriminations have been dismantled. But it still leaves a constitution that says nothing about that source of pride, nothing about those facts of our history. And that's really something we can make a fundamental change with in a yes vote later this year. And I guess the second thing is, as Bridget pointed to, we've got 3 institutions of government in our existing constitutional landscape as the central players: the legislature, the executive and the judiciary. And a yes vote at a referendum this year would introduce a new constitutional actor to the scene, a First Nations voice. And the focus of that voice, very importantly, and we'll probably get into this with some later questions, is on the political process, on the way that the first 2 of those institutions do their work, the Parliament and the government. And it's not a focus on the third of those branches, the judiciary. As much as possible, as Bridget said, people have deliberated about a proposal that is consistent with the way in which those 2 branches of government are in the foreground of Australian politics and constitutionalism. It seeks to work with them to improve the law making and the policy making that happens in Indigenous affairs.
My next question is, would a positive referendum have an immediate impact on the lives of Aboriginal and Torres Strait people? And what would this look like?
I hope that the voice will make impact as soon as possible, but I think we also have to be realistic that the voice isn't going to be set up within the first week or possibly even the first couple of months following a successful referendum. Those things will take time, and they do have to take time because it's important that we do get it right when the Parliament, the government, sets up the voice following a successful referendum. I've talked a little bit about the consultation that's been committed to already by the government with First Nations people to inform that piece of legislation to set up the voice. Once the voice is set up, I guess we would expect then the voice to consult with First Nations people to put forward the key priorities in our communities to make representations on. and then the process will kick off. I don't want Australians to think that if there is an immediate impact in the first or second year or third year, even in the first 5 years, that this has failed, because this is a long-term vision. We've tried bodies before. We've tried legislative bodies. We've tried various initiatives. The government have tried various initiatives. And when the Closing the Gap report is showing that we're not meeting those targets, those key targets that governments have committed to over the past decade or so, and we're not hitting them. So we do need to try something different here. If we're not seeing that immediate impact in the first 5 years, I hope that we do. We do see that impact quite quickly, but it doesn't mean that it is failing. These things take a lot of time. It's taken us almost 50 years to get to this point, to take that next step as an action to close or fix the gap that currently exists in our constitution. These things do take a lot of time. But that is why the constitutional element of enshrining the voice is so important, because it gives us as First Nations people stability. It allows us to plan and look into the future without running on political 4-year cycles that we're currently existing in, where every time you see a change of government, funding changes, services that are working really effectively get their funding taken away, and funding is distributed in other places. And we know, just by looking at the statistics, that as well-intentioned as policies or services might be, they aren't achieving the outcomes that we need in our communities. And I think that Australians genuinely want to see. We don't want to see those things existing in our country where First Nations people are dying nearly 10 years younger than the rest of the population, or where our kids are more likely to be incarcerated than get a tertiary education. Those things aren't acceptable to Australians, but we do need to try something different. This proposal of the voice has a lot of strategic thinking behind it, a lot of expertise behind it. And as a young person working in this space, I've just been able to sit and be exposed to all of that has gone on to get us here. It's not something that people have just developed overnight. And there is long-term thinking in this, that this is a mechanism that will allow us as a country to be more united, to move forward, and whilst dealing with unfinished business, to work towards better things rather than being stuck in the situation that we are right now. So I absolutely believe that the voice will make practical, positive differences to our communities by just having us at the table, by allowing us to provide our lived experiences, our expertise of our own communities, the issues we face, but most importantly the solutions, and putting that forward so that politicians can make better informed decisions, that they can create better informed policies and laws that affect our lives to result in better outcomes. That's the thinking behind this. So to answer your question, I don't think I did, but I don't want people to think that it's failed if we're not immediately seeing the impact of the voice 1 or 2 years into the process. This is a longer term strategy.
If I can just point people to that there was a really heartening article published in The Australian today about the voice. I don't always think that every morning, but if you have a look at it today or seek out the comments elsewhere online, Josie Douglas, who's a water woman from Alice Springs and policy manager at Central Land Council, talked about what the voice would get on with, what kind of business the voice would get on with if one was established as far as people from Central Australia are concerned. And she nominated 3 issues off the bat where she said the voice could change lives. That's why she and other people from Central Australia say they're supporting the voice, because they said it can change lives. And she nominated in the area of housing, urging the government to move towards an Aboriginal controlled remote housing operation, to give Aboriginal people the responsibility to fix the housing issues they face and to provide better tenancy support, as well as creating jobs. And jobs was a big theme of the second thing she pointed to, the reforms that have been made to the CDEP, the Commonwealth employment program that operates in remote communities. She described them as probably well-intentioned and in some ways had sounded like they may be improvements. But she also said the truth is that the bureaucrats in Canberra with which people in Central Australia deal have often been to a remote community perhaps once or twice and really don't understand the issues. And so she really saw hope in the voice being able to influence housing policy, a super urgent issue, obviously with huge flow-on effects for employment, education, health and so on. And then thirdly, she talked about food, nutrition in Central Australia and the incredibly expensive cost of fresh food and the pricing of ultra low nutrition foods as well. And the skewing effect that has on Aboriginal health in Central Australia. And despite having a huge evidence base from community-controlled health organisations and from other experts, they simply can't get that message. That message keeps being ignored in Canberra, and they want action in Canberra to see changes in policies on the availability and affordability of fresh, nutritious food in Central Australia, because they know from lived experience, Bridget says, and they know from the statistics and the evidence that it would make a really big difference. And so that's why the Central Land Council and big organisations like that in 2017 swung in behind the voice, because they saw this as the opportunity to break out of a cycle where it's simply too hard in our electoral process, which is dominated by majoritarian thinking, for 3% of our population that's dispersed across the whole continent to have that impact, to have their voices heard in the system.
Thank you for that answer, Sean and Bridget. The next question that's been asked is, the ability of the voice to make representations to the executive government have been a point of debate. In your view, is this a legitimate concern for cause or not, and why?
No, I don't think it's a legitimate cause for concern now. It was certainly a legitimate question to be raised, but I think it's a different thing for political people in Canberra, for example, to continue raising it when there's been such a clear and comprehensive answer provided to this concern. So I think it's important to separate two questions out on this one about the executive and whether it should be included in the provision. The first one is just the basic one of whether a representative of Aboriginal and Torres Strait Islander body should be able to make representations to the government of the day. And it seems almost everyone agrees that the answer to that question is yes. I think the reasons for that are obvious. That's what we have a democracy for, to make representations to the government of the day. It's something that different organisations and entities are doing in our community every day of the week. Legally giving a body the power to make representations to government as well as Parliament is in that sense no radical tampering with our constitution. It's entirely consistent. It's central and familiar to the way our constitution works. But it's where currently, as I said, the 3% of our population electorally dispersed across Australia cannot activate that mechanism as effectively as many others and have their voices heard on laws and policies that affect them. And it needs to be the government as well as the Parliament, because essentially if the government has gone as far as introducing legislation, then you're down to amendments in the Senate. And the government is largely committed to what it's already doing. And everyone recognised in this deliberative process that Bridget's described that if there's going to be influence that's meaningful, a meaningful say over laws and policies, it has to be back at the point when ministers and officials are picking up the pen, when they're deciding on the nature and the existence and the nature of a policy problem, and casting around, canvassing on what the options might be to deal with it. And that's where people need to also be having their voices heard, and through the process, continuously through that process to the point of lawmaking at the end. So that's the first question. The second question is a legal one about whether we should have concerns that the reference to the executive government appears in the Constitution. And the suggestion's been made that some hypothetical future High Court case might see the court imply some obligations on the on the government in that situation that would gum up the works of government, bring government to a grinding halt, or give undue, ability for people to hold up the processes of government. And the difficulty with that objection is that it's really either misunderstanding or misrepresenting what the intended purpose of the voice is, which is to change the political dynamic in Australian constitutionalism when it comes to Indigenous affairs, not to get the courts involved. Essentially, people like Joseph Douglas would say, we don't have the time for that. There's urgent business to get on with the political process, trying to influence law and policy. So the legal answer relates to three things: the text, the actual language of the amendment, the legislative materials that came into Parliament along with that text, which the High Court would look at in any future High Court challenge. And then thirdly, the overwhelming weight of expert opinion on this issue. And all three line up the same way. If you look at the text in this provision, subsection 2 of the proposed change, you can see it very clearly, carefully and deliberately being chosen to talk about empowering the body, giving it the core function of making representations, and very clearly and deliberately not talking about duties or obligations on the government and the parliament. Okay, so that's a deliberate, calibrated choice about the kind of proposal that could both change the dynamic but also achieve success at referendum. Then secondly, the Solicitor General for the Commonwealth has said this would not only not interfere with the operation of responsible government in Australia, it would enhance that system in an advice that's unusually been released to the Australian public from the Solicitor General, the Chief Lawyer advising the Commonwealth. And then when the bill went to the Parliamentary Committee, you had High Court judges, a former High Court Chief Justice, Robert French, a former judge of 18 years, Kenneth Hayne, Professor Anne Toomey from Sydney University, our own Professor George Williams, all saying the same thing as this objection was put to them. These are exaggerated or baseless concerns. And that's because the focus of this proposal and its very clear wording and the legislative materials that came into Parliament at the same time that the High Court would look at all made the same point. This is about affecting the way politics occurs in Australia and not involving the courts.
A lot of the No campaign has been geared towards the view that the voice will have veto power. Of course, this is unrealistic, but how will the voice be both empowered and limited? Do we risk the voice becoming an illusory yet tokenistic?
I think I would answer this one by looking at some of the key terms of reference that guided the regional dialogues, and they included things that meant that whatever reform came out of those regional dialogues could not affect or compromise First Nations sovereignty in any way, that the reform would respect democracy and parliamentary sovereignty. So there was that knowledge there that whatever reform we put forward, it would work within the system that we've got and respect the democracy that we've got. And in my personal opinion, it actually improves it. It adds more to it, and our democracy will be richer for giving voice to First Nations people on the issues that affect us. It's also very consistent with international human rights law and the United Nations Declaration on the Rights of Indigenous People when it comes to self-determination and our political activity. So, the voice will not have veto power, and that was understood well in the regional dialogues. But it is a mechanism that will bring forth political power for our community by having a requirement there for the Parliament and the government to listen to those representations and consider those representations when the voice makes them. That creates accountability and transparency, and the fact that this proposal to enact a voice has to go through a referendum process, which is not something that happens every day, especially one of this importance. The Australian people will have to say whether they see this voice, this body, as a legitimate institutional body whose core function is to make those representations on First Nations issues. So there is political power in that as well. If the government or the parliament decides not to implement those representations or recommendations, advice that's made in them, there will have to be a response to that as to why, and that creates transparency. Currently, even within my communities, there is constant consultation by government or government bodies with our communities. We turn up, we basically tell them what's wrong, we tell them here's what we can do better, but then that goes nowhere. This actually changes that relationship and says, actually, there's going to be accountability, and when we are consulted, you actually have to consider and respond to it. And if it isn't implemented, you're going to have to explain to the Australian people why. And that creates a lot of political power there, whilst also working within a system that already exists and respecting that as well.
Great. Thank you so much. Unfortunately, our time has come to an end. Thank you everyone for submitting your questions about the referendum. We'd also like to thank Sean and Bridget for sharing their insights with us and answering so many of our audience's questions. It was great to unpack this matter in further detail, share information about the upcoming referendum, and deepen our understanding so we can all be more informed. We want to leave you all with this short video that will be played on the screen, and we thank you once again for coming today.
I got a story to tell you. It's a good one. It's about how these people, the first people, got a voice.
60,000 years they've been speaking.
Had 363 languages.
But no voice. No say on matters which affected them. It wasn't right.
So, me and your granddad.
Me and your mum.
The whole nation did something about it. People called their friends and families. People talked about it on the streets, talked about it at work, on the field. Everybody made a song and dance about it.
Everyone walked side by side.
And that's how we changed this country for the better. How we made history.
Is that story true?
It could be.
Authorised by the Uluru Dialogue Sydney.